Okay, let's talk the RICO Act. The RICO Act, Racketeering Influence and Corrupt Organization Act, is a 1970 U.S. federal law designed to fight organized crime by targeting criminal enterprise, allowing prosecution for a pattern of racketeering activity like bribery, extortion, fraud, drug trafficking, and money laundering, even if individuals aren't directly linked to the laundering, even if the individuals aren't directly linked to the leadership of this crime group. By connecting seemingly unrelated crimes to a common enterprise, it provides powerful tools for both criminal prosecution, heavy fines, 20 plus years of prison, forfeiture of assets, civil lawsuits, triple damages, extending beyond the mafia to white collar crime and corrupt officials. White collar crime and corrupt officials. Key aspects of the RICO purpose to combat infiltration of legitimate business by organized crime. Enterprise can be a legal entity like a company or an informal group like a gang. Pattern of racketeering requires committing at least two predicate acts from a list of 35 crimes within 10-year period related to the enterprise. Predicate acts including murder, kidnapping, arson, bribery, drug dealing, mail wire fraud, etc. Penalties up to 20 years or life per count. Fines, forfeiture of illegal gains. Treble damages in civil cases. How it works: RICO powers lies in linking seemingly separate crimes, like a series of frauds or extortion acts, to a common criminal organization or enterprise, making it easier to prosecute leaders who ordered crimes without directly committing them. Broader use: while created for the mafia, its broad language allows it to use against various groups, including corrupt public officials, corporate criminals, and even some protest movements. What the heck? Where did it
in the public interest of...
I'm sorry. I wanted to read that to you.
Same in the public interest. You can kick rocks if...
Okay. Okay, so I just read you the RICO Act, okay? Citing conspiracy against rights under the color of law. Conspiracy against rights under the color of law. This is all you got to put on your complaint form. I actually got a guy out of prison on a late notice of appeal from Centralia Prison. And he was out within 2 weeks of filing that late notice of appeal. And this is what I said. But he was the one that sent it in. When my name's attached to anything, nothing happens. So I just wrote it out, and he had it notarized, copies, shared it with family and friends, and had it forwarded to the court. A conspiracy against rights under the color of law. The judge failed to report my counsel and the opposing party for multiple counts of misconduct and themselves for judicial misconduct. The opposing party failed to report the judge for judicial misconduct. My counsel for ineffective assistance of counsel and themselves for misconduct. My counsel failed to report the judge for judicial misconduct. The opposing party for misconduct and themselves for ineffective assistance of counsel. Reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. Failure to report misconduct, just as well as failure to enforce one's constitutional duties as prescribed in the rules and the codes, the lack of requirements of the Sixth Amendment of the U.S. Constitution is beyond unethical. The lack of effective assistance of counsel doesn't allow for a fair trial, which shows due process didn't exist. Deprivation of rights beyond its entirety. It clearly shows the judge and the attorneys in my case committed a conspiracy against rights under the color of law, which prohibits the willful deprivation of privileges or immunities under the color of law. Prohibits conspiracies to injure, oppress, threaten, or intimidate any person in the free exercise and enjoyment of the right or privilege secured by the Constitution or laws of the United States. I trust you will live up to your oath and show competence, diligence in expediting litigation, as I have meritorious claims and contentions. So I strongly stress reporting professional misconduct and maintaining the integrity of the profession. I trust communications will be made for ethical violations, and every penalty will be imposed in the public interest, which is a law. As trustees, this is how to maintain the public trust. The public trust doctrine will explain that to you. Failure to do so would add to this conspiracy against rights under the color of law. That was what got him out of prison on the late notice of appeal. His lawyer didn't file the appeal. Didn't file it in a timely fashion. Cost the guy $7,500, and he thought he was lost, and his wife put the house on mortgage or whatever. And this was 91, I think, or 90. And I felt bad for him. Not too much him, and not even his wife's tears, but it was a kid. There was a kid involved, and he didn't understand why I did it. But see, a lot of people don't understand why I helped them. It always starts out with the children. There's always children involved. And I remember what it's like being a kid. So it was, as they say in Spanish, for the children, los niños. I forgot it, but for the children. Okay, so if you go in court and you want the judge to throw the case out, so you got a case going on right now, you want to refer to the Code of Judicial Conduct, okay? Now the judge will tell you, you need a lawyer, talk to your lawyer, get a lawyer. Now, my buddy Bob, he was fighting for child custody. He was getting his wages garnished, etc., having to pay child support and medical insurance for a child that wasn't his. And he was having to pay that for a child he had custody of, So I told him, just go to court, file for an appearance. And so I went with him, showed him where to go. He filed for an appearance, filed for a waiver of fees to avoid any court costs. We took the rules and the codes. And when he tried to speak to the judge told him, you need a lawyer, you need to get a lawyer. And he said the lawyer will be ineffective at this point. And he says, what? He says, yeah, Mario, what's that called? Yeah, ineffective assistance counsel. Yeah, he would be ineffective at this point in juncture. And the judge says, you need to get, he says, Your Honor, I have a right to speak. Okay, so a judge shall perform the duties judicial, impartially, competently, and diligently, ensuring the right to be heard. See, so, and the judge asked him, where do you get this? And he asked me, Mario, what's that called? I said, the Code of Judicial Conduct. So the judge let him speak. Because he, that's performing his duties. Okay, so if the judge didn't, then the judge would be violating Rule 2.15, responding to judicial and lawyer misconduct. So he was telling the judge that the opposing party was filing a frivolous and fraudulent claim because he had custody of his son. He came with affidavits from the teachers from the school. He signed his kid up for school, kindergarten, first grade, second grade, third grade. Kid was seeing a counselor, because, problems between mom and dad. Dad had complete custody control. So he got affidavits from all the teachers, the principal, the cop at the school, the doctors, because his son had some medical issues. So he got affidavits from the doctors, about how they knew Bob and his son, Billy. and how long they've been going. So he had all these affidavits, notarized affidavits, and he took them to court, and he ended up the judge. Judge says, what's this? He says, expediting litigation. So he got all these affidavits so nobody would have to come to court and testify, and it'd be actually stupid to have these people come to court to testify. Hey, did you write this? Did you sign this? Yes. I mean, they can't question what's already been noted in court record as their statement. Okay, so that's all he had was over a dozen statements, legal statements, notarized affidavits, even from his landlord. He even brought a copy of his lease, which showed the apartment was rented to him and his son, his young minor son. The guy from the corner store knew him. Every day after he picked his kid up from school, he stopped at the corner store and let him get his little snack. So he brought all these affidavits, and the judge yelled at the opposing party, the attorney representing his ex, or soon-to-be ex. That got him, they stopped garnishing his wages. He ordered to return his money. She had to get a job to pay back the state. And but the judge didn't report the lawyer for misconduct. The judge knowing that another judge committed violation of this code. So if a judge knows of any judge that violated the code of judicial conduct, or the rules, or a lawyer that violated the rules of professional conduct, is supposed to report them. Failure to report misconduct is misconduct. So I'm showing you that once a judge violates one canon, it's impossible just to violate one. You wind up violating multiple. Okay, so this is just showing you what happens. Comply with the law. So a judge failure to report misconduct, reporting misconduct is mandatory. So compliance with the law. That's 1.1. 1.2, promoting confidence in judiciary. I mean, okay, so when you tell the judge is going to know that, if he doesn't report this lawyer, or even himself, because a judge's failure to report misconduct is contempt upon the very court they're presiding over. So you might want to remind them of that. Your Honor, failure to report my attorney for ineffective assistance of counsel or the opposing party for multiple violations of the rules of professional conduct is a lack of gives me a lack of confidence in the judiciary. So you're going to wind up citing them for a lot of things. Okay, Rule 1.3: avoiding misuse of the prestige of judicial office. Failure to report, even for they have to report themselves as well. And remember, them not reporting anybody in the very beginning which is really wrong. Them not it is contempt of the very court. So there's multiple counts of contempt of court. Failure to report misconduct is the judge knowing it willingly. Giving preference to the duties of judicial office. Duties of judicial office as prescribed by law shall take precedence over all the judge's personal and extrajudicial activities. Impartiality and fairness. While the judge is supposed to make sure your lawyer, or the opposing party, everybody's living up to the rules of professional conduct and the code of judicial conduct. Right? It's everybody's duty in that court of law to make sure everybody abides by and enforces it. The judge is actually supposed to make sure that your lawyer doesn't violate these. They're supposed to be watching for that. And they know it. I mean, what'd they go to law school for? Not to learn this? See, the judge shall not, in the performance of judicial duties by words, conduct, manifest bias or prejudice, or engage in harassment, including but not limited to bias, prejudice, harassment based on race, sex, gender identity, religion, national origin, ethnicity, pregnancy, disability, age, sexual orientation, marital status, socioeconomic status, and political affiliation, and shall not permit court staff, court officials, or other subjects to the judge's direction and control to do so. Well, you'll say, hey, well, the Supreme Court just allowed racial profiling. Well, that's because they think they can do that because they say they don't have a code of conduct. But that's in the interest of the bar. That's not in the public interest, which basically makes that under the color of law and null and void. Legally speaking, of course. Proceedings before the court shall be conducted without manifesting bias or prejudice or engaging in harassment based upon. See, so if you even try to talk to the judge, if you don't have the codes with you, don't try to remember it. Print it out, highlight every issue, and take it with you. You might want to take copies for the judges and the lawyers because they will act like they don't know what the hell you're talking about. They will. And don't tell your lawyer, because if they're not living up to their duties, they're not going to. If you complain to your lawyer, he's going to go complain to the judge, and somehow or another, they're not going to let you back in court, and you're going to just... But don't go alone. Make sure you take some people and tell the judge you want this recorded, you want this on the record. Okay? Remember, you have a right to a public trial. A public trial is just not the right just to the defendant and or the plaintiff, but it's in the interest of the public. Okay, a public trial is in the public interest. So they can't close the doors. It's ridiculous if they do, but they'll do it just because you don't know that you have the right to a public trial. The public has a right to that trial being public so they can know what's going on. So look, this is a lot of stuff that you can cite the external influences on judicial conduct, competence, diligence, and cooperation. See, so you're going to find it's impossible for the judge just to violate one code of conduct. So, and the lawyers in the courtrooms are letting them do this. Okay. So it's telling you a whole lot to... I'm sorry, I don't mean to be laughing. It's just, that's my defense mechanism for expressing pain instead of swearing, yelling, screaming, breaking things. I laugh and make jokes. So don't take that as an insult. I'm not laughing at you, I'm just hiding my pain. Not just because it happened to me, but it's happening to so many of you, all of you. I mean, none of this happens in a court of law. So no matter what court you're in, you're going to want to take the rules and the codes with you and highlight every issue you have a problem with them not fulfilling. These are the legal obligations, the constitutional duties of all lawyers and judges, even the U.S. Supreme Court. They can say, how is that in the public interest? How is it in the public interest, which I showed you, a legal obligation to do what's in the public interest. How is it at a public interest that they put themselves above the law? They're going to say, well, the other judges, but that's just so, rich people. I did a video on how the scales of justice, on a monetary scale, justice goes to the highest bidder. So that means you run out of money. They can kick it up to the U.S. Supreme Court. The U.S. Supreme Court says we don't have a code of conduct. We're above the law. We don't even need qualified immunity, which qualified immunity is contrary to the rule of law. I mean, any law repugnant to the United States Constitution is null and void and cannot stand, which was established or said by Thurgood Marshall. I forgot exactly what year. So how can they establish qualified immunity as law when it's repugnant to the rule of law? It cannot stand. It's null and void. I mean, if you put it in its simplest form. But somebody will try to contradict that or complicate it by violating the letter of the law. and try to tell you it doesn't mean what you think it means. Look up the penalties for violating the letter of the law. Remember, if they violated the letter of the law, that's disinformation. Look up penalties for disinformation. Okay, people, so this is a lot of stuff you could use against them. Okay, so I just showed you the small part, but you're going to have to, people always know, why do I got to know this if they know that's their job? They know you know it's not their job, so why they got to do it if you don't know? And they ain't going to tell you, because if they were going to tell you, they would have told you already, and I wouldn't be the one going through this with you, okay? I founded it back in 79, and I've been trying to teach as many people as I could. Okay, so, and it's impossible to violate just one rule. You know, it's a rule to be competent. And these are laws, okay? Just because it says a rule, it says in the preamble, in the Rules of Professional Conduct and the Code of Judicial Conduct, that these are laws or any other applicable laws, okay? Scope of representation, allocation, okay, diligence, okay. So remember I was telling you on the internet, even lawyers and judges tell you only criminal trials have a right to a quick and speedy trial, and there are limitations on that. And it's rare that anybody fulfills that, so it's easy to get out on a violation of a quick and speedy trial. You could literally be on death row, and if you were denied a quick and speedy trial, which is your constitutional right, you know, then the case is null and void. You could have it thrown out with prejudice, and then use all this other stuff against it because they didn't get informed consent for you to bypass a quick and speedy trial. And most of the time, they use all that time to convince a person to cop out. Okay, communication. You know, they should be communicating this to you, you know, about their competence and being diligent. You know, if you're not diligent, you're not competent. It leaves you incompetent. So when you talk about fees, every and any fee is unnecessary by the simple fact that they've failed to live up to their constitutional duties. They took an oath to do this. Do you know what the penalties for violating the oath are? Okay, look up penalties for violating. That's another law they broke, okay? Client with a diminished capacity, you can use that, because in order to give informed consent, you must receive reasonable knowledge to make an informed decision to give informed consent. And by this point, you realize that what you need in order to give that reasonable knowledge is the legal knowledge of those responsible for deprivation of rights under the color of law, for those committing a conspiracy against rights under the color of law. So in order to give that informed consent, the reasonable knowledge is the legal knowledge of all lawyers and judges to give informed consent. Okay, that's the only way. I mean, how? Nobody's telling you this. Declining or terminating representation. Lawyers will quit on you at the drop of a dime. You mentioned the rules of professional conduct, the code of judicial conduct. And the judge won't do nothing about it. It's against the law. They can't do that. They got to give you time to find proper representation to replace it, but they won't. So you'll have to go to the rules of professional conduct and go through. And each rule definition of what it means is maybe a paragraph, 2 paragraphs long. Not very long. Longest one is Rule 3.8. Safekeeping property. They don't do that. People in conservatorship, guardianship, probate court really have something going for them if they use the rules of professional conduct, because who is diligent in the communication about the restrictions or the limitations, you know, on safekeeping property? Nobody's properly doing that. So if they're not doing that, they're not doing any. Even if you don't have a lawyer, remember, in fairness to the opposing party, you know, it's one of the rules. Okay. Expediting litigation, candidate towards a tribunal, I mean, it's hard to, the only one that's going to give any candor towards the tribunal is you, because even the tribunal knows that there's no candor in there if nobody's abiding by the rules or the codes, okay? Fairness to the opposing party and counsel, so even if you are unrepresented, they still have to treat you, give you the same fairness that they would any other attorney, judge, but they won't. Trial publicity, there's limits on what can be said about an ongoing case. Special responsibilities of a prosecutor. If you have exculpatory evidence, you can just shoot over there and tell them, hey, I have exculpatory evidence. It's your job to exonerate me. The rules of professional conduct say so. You took an oath to do that. That's the requirements of effective assistance to counsel. In the Sixth Amendment of the U.S. Constitution, failure to provide effective assistance to counsel is a lack of a fair trial, which is a lack of due process. Okay, see, it's depending on how you look at dealing with an unrepresented person. A lot of times, I've had it happen to me many times. I was in eviction court twice. Both times, lawyers thought they were all happy and sassy, but I used this, but they knew I was unrepresented and tried to talk me down. I put them in their place in court using the rules. Responsibility of partners, managers, and supervised lawyers, you want to read that. Responsibility of subordinate lawyers, you'll want to read that. Reporting professional misconduct is mandatory. And then if you look up misconduct will say not doing any of this, as well as what's in the preamble. Okay, so I just wanted to go over the RICO Act, okay, and give you a slight understanding of what you're dealing with, what you're up against. Anytime, every time you step into a court of law, if you don't bring this with you and make sure that it happens, it's not going to happen. I'm telling you, you don't have a shot without the reasonable knowledge, the legal knowledge equal to that of those you oppose in a court of law, which is even the attorney that you hired to represent you, because if they are living up to the oath that they took in order to become a lawyer, they would be discussing all this with you, not I. All right, people. Nothing but peace and love for you, all right? Wish you nothing but a long life and good health. May your Creator always be with you. And may many, many blessings. And may this be some or one of the many blessings He rains upon you as He did me. Knowledge is power. Read to succeed, my friends. This is Legal Reform, signing off.